now we're going to go right into the questions that have already been submitted. It looks like we have, we've got some great questions. Looks like we have over 12 questions. So what we typically do is I state the question, give a quick answer. So first question is, if the community wanted to take action to remove a director, does signing a petition constitute a vote by proxy? I've read a couple of times that a group of homeowners marched into a board meeting with a removal petition in hand and tried to dismiss multiple directors. However, the state statutes state that a special meeting must be called for a vote. Would a signed petition stand the test of a vote? And if we gather the signatures for a removal petition, could a separate proxy be gathered at the same time to be presented at the special meeting? Okay, so here's some thoughts on the board removal process. So remember that it doesn't matter what your bylaws state. Some bylaws are outdated and don't have the correct procedure in there on how to remove a director. You have to follow what Arizona law states on removing a director from office. And we have a really good summary that we have on our website if you're in the market to remove your board or remove a member of your board. And that's on our top 10 cheat sheet. You can go to mulcahylawfirm.com, click on cheat sheets, go to the top 10 cheat sheet, top 10 things you need to know about Arizona law. It's number 6. Bottom line is there's a whole process under Arizona law. The process starts with a petition being submitted to the board. That petition doesn't summarily dismiss the board, right? The petition is you have to meet certain benchmark requirements. So for example, if your association has fewer than 1,000 members, either 10% or 25% of the owners must sign the petition, or 100 owners, whichever is less. So if you're in that category, you'd have to submit a petition signed by 25% of your owners. It's 1 vote per lot or unit. And then the board has to follow a process to, verify the signatures, see if anybody who is delinquent signed the signatures and do they still have the 25%. And then if they do, then we have a meeting 30 days out, whereby the entire community can vote on whether to, remove a director or directors or retain them. So if you want more information on the full process, go to our cheat sheet, top 10 cheat sheet, and it's number 6 on that top 10 cheat sheet. So short answer would be no. If owners march into a board meeting with a petition that is not following the law and it would not be considered a valid removal of the board, there's an entire process that has to be followed. Okay, our second question. This one is submitted from an owner. Can we leave or remove our HOA? Our HOA just collects money and doesn't do anything. We need to tell them what to do. Okay, so this is obviously written from an owner's perspective. So can you leave, being a member of your association? Well, if you sell your property, yes, but it's very impossible basically for you to remove yourself from your association. And so you might be considering removing your board. We just kind of talked about that process in the last question and answer. What you might want to do is volunteer to be on the board, and maybe you'll find some more information about, what are the challenges the board's facing and what exactly they do for your association, and maybe you can roll up your sleeves and help. Question 3, is there a list of recommended flat roofing contractors for a roof replacement in a condo association? Here's something that we could do, if you're interested in doing this, there's a Facebook page or Facebook group called Arizona Self-Managed Homeowners Associations. You might want to throw that on as a question on that Facebook page and see if you get any recommendations. I would recommend that you ask other associations that are close to you that have flat roofs. Hey, who do you use for your roofing contractors, and are you happy with them? Ask your management company, do you have any experience with roofing companies that handle flat roofs? You may want to go to, there are several trade groups that are for roofing companies, and ask them for recommendations or names of companies, and then interview them and check their references. The next question is it required that every board member be at every meeting with a vendor, or just gathering information? Okay, so the question is, we're having a meeting with a vendor. Does it have to be everybody on the board there, which makes it obviously an open board meeting? You'd have to give notice, or can we have fewer than a board, full board, or a quorum of the board? It really just depends on how your association operates. Most associations, I mean, usually there's one person on the board who takes the lead on, having a meeting with a vendor to discuss something, and then they come back and report to the board. Typically, that's the president. But other associations, they have the vendor come to a board meeting and give updates. It really just depends. So is it required? No, it's not required that every board member be at every meeting with a vendor. That's an unreasonable request, in my opinion. Okay, next question. I am a director. Can I directly ask our landscaping the watering schedule because our property manager does not take action in a timely manner? Okay, so you're a director of your association. What I would recommend that you do here is at your next board meeting, talk with your board about this and say, I am interested in finding out what the watering schedule is. Can the board direct me to have a communication with the vendor on this topic? What you don't want to have happen, and vendors don't like this, is when they have multiple board members contacting them, asking different information. The vendor really probably wants only one or two contacts for the association, maybe the manager and then a board member that has authority. So keep that in mind. Next question. If a newer management company is aggressive in issuance of new and repeated violations for weeds or trash cans out, is it likely at the request of the board? Would a more gradual transition to stricter enforcement be recommended? Okay, that's a really good question because this does happen. Remember when we talked about different management companies having different strengths and weaknesses? So some management companies, when they come in as a new management company, the first thing that they'll do is they'll do a full inspection of the property, and maybe they're going to be pickier or more strict than the prior management company. And the first thing that they do is they issue a whole bunch of violation notices. That may not be the best PR move for the new management company or the board because it gets everybody all upset. So what I would recommend is, at the time that there's going to be a management change, if one of the issues is, hey, we're going to be cracking down on violations more, I would be sending out notices to your owners saying, just general notices to all owners saying, one of the goals of the board in 2022, the summer of 2022, is that we're really going to be, more focused on making sure people are maintaining their properties and making sure that people are putting their trash cans in, at the times that they're supposed to be doing. So giving them some warning, talk about it at board meetings, and then gradually ease into these notices. And maybe the first notices that you're sending out are courtesy reminder notices, maybe a little bit friendlier wording. Okay, next question. New owners in a 55 plus condo association have not provided a permanent resident of the appropriate age and have been asked to sell. The unit is now for sale. Can the association ask them to vacate the unit before it's sold? What are the options for the association? Okay, so we've got, apparently there's a 55 and over community association or condo association where the resident is not 55, or at least one resident is not 55. And for whatever reason, the board is enforcing their CCNRs, which is fine. And the unit's for sale. So can the association make them vacate the unit before it's sold? I mean, I'd have to look at what your documents state, but probably yes. What are some options that they, would have? The board can make an exception. I mean, you have to look at what the documents state, right? So one exception would be that, state law or state and federal law says that only 80% have to be 55 or over. One resident in the unit has to be 55 or over. Maybe you put them in that 20% category. Or maybe you take a real strict approach on it. It just depends how your association wants to handle it. But I would recommend that the board be talking to your attorney because fair housing issues are complicated. And they want to make sure that if they are asking the owner to vacate the unit, that we're on strong legal ground. Okay, next question, number 7. I'm always cautious about change. Oftentimes, you just trade one problem for another. That said, is it reasonable to expect the management company to be an informed, trusted advisor, such as financial ideas, guidance, 5 and 10-year budget planning, capital budget planning? In my experience so far, it seems that they are just very administrative and not problem solving. Do I expect too much or too little? This is a really good question. So I think we kind of hit on this a little bit in the presentation when we talked about, having a management company that meets your needs. So it's hard for me to say, should you change because of these issues? Budgeting type things, long-term planning for your association. If they're really strong on the administrative side and they're doing a good job, maybe you have the board take more of a lead on some of these, long range planning items, especially if you have somebody on your board who has expertise on that. But if you're an association that is looking at, a plethora of problems and there's a lot of deferred maintenance and, things aren't going well because you don't have a plan on any of these things, maybe it is time for a change. Or maybe the management company that you have needs to shift their focus to helping you dig out of the problem. So, do I expect too much or too little is your question. It really just depends. If this is something that is the most important part of your responsibility as a board, then maybe you do need to bring in an expert. If not, and there's other people on your board that can come in and help as volunteers, help you come up with these ideas, or maybe you bring in an expert to help you on some of these things, that could be an option as well. Question 8, who should oversee the work of vendors such as landscapers, the manager or the committee chairs? It really depends. I mean, the board makes the decision on this, and maybe the management contract says the management company is responsible for this. Maybe the committee chairs are doing it per the direction of the leads the board. It really just changes from every association. So you have to do what's best for your association. Question 9, what information needs to stay forever in lot files? We are an age-restricted community and have years of personal IDs verifying age compliance and previous owner applications. What can we get rid of? What must we keep? Okay, we have a great cheat sheet on records retention. So I would encourage you to go to our website, mulcahylawfirm.com, click on our cheat sheets page, type in the keyword records, and that will give you some really good tips on what to keep and what to toss in lot files. As a rule of thumb, any current owner, there has to be some thought on these files, because if you're an age-restricted community, you have to make sure that at least one resident is age 55 or over. And so you wouldn't want to go back and just do a mass toss of records. If a current owner, if their identification is maybe from 15 years ago, but it, is still relevant, we'd still have to prove that, that it's still got that identification if we get audited under the Fair Housing Act. And so I think, what I would recommend is you'd have to sift through those files to determine what is no longer, needed. So if you've got somebody in there that's identification information from 15 years ago, they haven't owned the property in a long time, the statute of limitations has run, that would be something that you could get rid of. So you really have to look at this on a case by case basis. I can't just tell you to toss a bunch of records. I would say that if the owner hasn't been an owner for more than 7 years, or the owner or the resident hasn't been residing there for 7 or more years, you could probably toss it. But some associations, now with the ability to scan things, they might just keep it in online file. Okay, our 10th question is kind of a little bit longer question. Is there any source of reasonable expectations for management companies? For example, we are seeking improvement in tracking resolution of owner requests as signed action items, managing compliance issues. Our company is having difficulty and resisting providing any kind of clear reporting, saying that requires manual effort. Are we being unreasonable to expect this type of reporting? Other service companies use software packages that make tracking tickets easy. Is that not available, overly expensive in the community management industry? We don't know if changing management companies will help resolve this, or if this is an issue with all management companies that we simply need to live with. Okay, so great question. I think it is a reasonable expectation for your association to have a manner to track owner requests and how they've been resolved. I think whether it's manual or electronic, that's something that your management company should be doing. Because ultimately you answer to the owners, and if the management company is not responding to the owners, it makes it look like the board isn't responding. Also assigned action items, one way to make them accountable would be to ask them to do that Friday email to the board in terms of where they are on that. Also managing compliance issues and delinquencies should be just a report in your monthly packet. So I think that the tracking resolution of owner requests, if they don't have an online system that you can look at it in real time, that it's been done and what's happened, they should at a minimum put that either in the Friday email or in the board packet, how that issue was handled. Same thing with the compliance issues and non-payment assessments. Those should all be provided in a report at the board meeting. Okay, next question. If a newer management company is aggressive in issuance of new and repeated violations, looks like I think we already answered that question, so I'm going to skip to the next one. Are there requirements for all board members to approve communications, such as newsletter, meeting recaps from the manager to the homeowners? We have experienced difficulty in getting communications out because all 5 board members have not responded to the draft provided by the manager. How to best handle communications? Do we have to wait for 100% approval, or can we tell board members to reply by a certain date? Otherwise, the mailing is going out. I think that's actually a really great solution. Sometimes people get, tied up in trying to make things perfect, and it's better just to get it out, right? And so I think a good way to handle it would be give them a reasonable period of time for the board to respond to any changes they may have, and I would say that's maybe 1 or 2 days. And if they don't respond by a date certain, that the mailing is going to go out to the members with the update. I think that's a really reasonable response. Okay, question 12. Looks like we only have a few more questions. So that's great. Can board members talk to each other without the management being present? That's a really good question. So a couple ways to analyze this. Well, number one, anytime you have a quorum of the board present discussing association business, it needs to be an open board meeting. So unless it's one of the executive session topics where you can go into executive session, but almost all the board's discussions really should be done in the open session, unless it's, like advice from legal counsel, or, you could talk about performance of a vendor. You could do an executive session if that's what you're going to be talking about as a board. So can the board talk to each other without the management being present? So of course, remember, go back to some of the basics that we talked about here today. The board is the team captain. The board is the boss. So you make decisions as the boss, right? And one decision that you can make is, hey, we'd like to have a discussion of the board, maybe about the performance of the management company. And we want to do that in a confidential setting without the management company present. The best way to handle that is to just be honest with the management company and say, we're going to be doing a review of how things are going, and we're either going to be doing it, typically this is going to be something job performance you can push over to the executive session. And if a quorum of the board is going to be present, you still have to provide 48 hours notice to the membership that you're having an executive session and what you're going to be talking about. And you absolutely have the right to do that. So if your management company is saying, I have to be present, that's a power play, and they don't have to be present. But somebody else on the board who is present should be taking minutes, if minutes are needed. And those minutes should be placed in the official records of the association. So talk to your attorney if you're having problems like this, because it does seem kind of like the management company is trying to be there during all your discussions and maybe trying to pressure you, for them to be there, and they really, you're the boss, and you're the ones that would make that decision. Next question, number 13. Do you have a cheat sheet when a declarant or development is not performing per the CC&Rs? An example is the declarant has not appointed an HOA board of directors. So I do have a cheat sheet on transition from developer to homeowner control, and you can find that on our website at mulcahylawfirm.com. Go to our cheat sheets page and type in transition and developer, and it should pop right up. So question, what if they're not performing per the CC&Rs? So I'm guessing that your CC&Rs have a provision that say that after a certain percentage of lots are sold, that the board should be appointed or elected as a homeowner control board, and the developer will no longer have the weighted voting and will no longer serve on the board. And so if your developer is dragging their feet on that, what I would recommend you do is form a transition committee to help the developer make that transition, maybe with the developer's blessing or maybe without the developer's blessing. Reach out to an attorney that can help you with the transition process. Talk with your management company about it. They should be giving the developer advice about when the transition should be taking place. And start documenting in writing the fact that, hey, the transition should have taken place. It hasn't yet. What is your intention, developer, going forward? Because you're violating the CC&Rs right now. Okay, question 14. Please describe the Friday email concept that you mentioned. Is there a cheat sheet or other doc that explains more about what this would include? Great question. I don't have a cheat sheet on that, but I think that's a really good topic for a blog article for our firm. Make sure you're checking out our blog because we put a lot of great information in the blog for our firm, and that can be found on our website. So just the Friday email. So what I would do is direct your manager that every Friday before they sign off for the day, that they send an email to the board with important information about what happened that week. So for example, what I worked on, what I accomplished, something that I wasn't able to accomplish, but my plan for working on it next week, any problems that I need direction on, that's pretty much it, or any information that you want the board to know about. It can be fine-tuned and tailored for however your board wants the information to be, given to the board. It's not a board packet. You don't want the board or the management company to say, this is like getting formatting for board packets. This is unfair. This is too much work. No, this is just a informal email telling them what happened this week, what's my game plan for next week, and what do I need direction on anything from the board. And really, if the management company or the manager wants to have a good relationship with the board, this is just the path to do that, because it's showing that you're working in between meetings on things and you're communicating all things that are the sign of an A+ community manager. Our last question, our management company failed to send notification of tonight's open meeting. To whom should we complain? Well, it depends, because I have to know, if any notification was provided. So I'm assuming this is an open board meeting. Under the law, the association is required to provide 48 hours notice of any open board meeting or any executive session board meeting. And I don't know, maybe they put it on the website, or maybe they posted it on the common areas. So I'd have to hear the management company's side to that. So what I would do is, you're asking who you should complain to, I would go to the meeting tonight and ask the board, could you let us know how tonight's meeting was provided notice to the membership? How did you provide notice? And just remind them of their requirements under the law to provide that 48 hours notice. Now, if you want more information on the notice requirements, go to our cheat sheet on board meetings or compliance with the Arizona open meeting law. And both of those cheat sheets can be found on our webpage at mulcahylawfirm.com. Okay, well, thanks again for joining us today for class number 5 of our 2022 Virtual HOA Condo Academy. So great that we had over 107 people here and more than 12 on Facebook. So 107 on Zoom, 12 on Facebook. I'd like to take this time again to thank the neighborhood services departments from the city of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe for their partnership and teamwork with our firm to put together these amazing virtual classes. A friendly reminder, our firm's live virtual First Friday free call-in will take place on June 3rd, first Friday of June at 9 a.m. You can visit our firm's website at mulcahylawfirm.com for more information. First Fridays is an opportunity for anybody, board member, homeowner, manager, to ask one question free of charge regarding your association. Finally, next month, we've got a great class topic lined up. We urge you to join us for class number 6 for our 2022 Virtual HOA and Condo Academy, scheduled for Tuesday, June 21st at 11 a.m. Next month's topic is how to amend your association's CC&Rs, bylaws, and rules. We're going to be discussing the new Arizona Supreme Court case that is kind of a game changer in how we're handling and managing CC&R amendments. And as always, we're going to have a free question and answer period at the end. So I hope you'll be joining us next month for our First Fridays on June 3rd, and then for our 6th class of the Virtual HOA Academy on Tuesday, June 21st at 11 a.m. Thank you again for joining us today. Thank you for making your communities better, and we hope to see you soon at a future virtual event. Take care, everybody. Bye.